All right, I may as well get going then. I guess it's 4:30 and happy to introduce myself. I'm Andrew Latimer. I'm a UC Davis professor in the plant sciences department. And I'm also currently serving as acting director of the UC Davis Institute of the Environment. So in that role, I am very happy to get a chance to introduce our next speaker in this seminar series. And we have today with us Nell Green Nylen. Dr. Green Nylen is currently a senior research fellow at the Wheeler Walker Institute at the Center for Law, Energy, and the Environment in Berkeley, and that's affiliated with Berkeley Law. And she has a really interesting and broad background in both science and policy. She has a PhD from Stanford, looking at past climate change, mostly in Northern California. And then she switched over at some point and started studying law and has a law degree from Berkeley with a focus on environmental law. And the research that she's been doing spans a really kind of the whole range of water issues that we face in California. And this is including the groundwater, which is such a big deal these days. And she's been helping to actually implement or advise on the implementation of the recent Sustainable Groundwater Management Act, but also other things like thinking about drinking water and how to improve safe drinking water access or affordability for lower income people. And so, yeah, these are really critical questions for California, for all kinds of dimensions and levels and people and communities in California, because drinking water affects us all. A lot of groundwater affects many communities and certainly affects a lot of agricultural producers. And then we're all agricultural users, of course. Um, and so I'm really excited to learn more about this from her and begin learning about her work in particular today. And so I'm really happy to welcome Dr. Green Nylen on behalf of the UC Davis Institute of the Environment. Welcome. Looking forward to your talk.
Thanks so much, Andrew. Yeah, I'm really happy to be here. Let me go ahead and share my screen. Get the proper thing here. And make that go full. Okay, can you see my slides?
Yes, it looks good.
Okay,
It looks
great.
good.
Okay. Yeah, thank you so much for the invitation to speak. I'm really excited to be talking with you all today. As the title here suggests, my presentation is going to be focused on water allocation in times of scarcity in California and kind of how the state can improve its approach to managing water scarcity more generally. In my eyes, I'll just give you a little preview here. This should look more like coordinated, ongoing, proactive water management that acknowledges the reality of variability, uncertainty, and increasing hydrologic extremes, both dry and wet, rather than what we've had a lot in the past, which is kind of frantic disaster response. So since 2014, in my work at CLE, I've paid a lot of attention to the state's role in preparing for and responding to drought, especially the role of California's key water regulator, the State Water Resources Control Board. I've also worked on a variety of projects, as Andrew mentioned, that touch on managing groundwater, including analyzing considerations for implementing the 2014 Sustainable Groundwater Management Act. Today, I'm going to start with a kind of overview of some important context for understanding California water management. And that includes sort of the basic hydrologic and institutional landscape, as well as a brief overview of water rights in California. Then I'm going to be talking about how California has allocated groundwater and surface water, primarily during times of scarcity, since that's when that really comes up. And as I go, I'm going to touch on some of the recommendations that my colleagues and I have for making future water allocation more fair and effective. So first, for a sort of incomplete overview of California water. California, as you may be well acquainted, has a unique precipitation regime that is highly variable across both space and time. So the amount of precipitation that the state receives often varies really significantly from year to year, bouncing between different gradations of wet and dry with essentially no average years. This map really highlights that California is unique for having such a high degree of year-to-year precipitation variability, with the greens, blues, and black signifying the most variation and pink signifying the least. And then in any particular water year, rain and snow fall mainly during the cooler months, and as the map on the left shows, are focused in the North Coast and the Sierra Nevada. However, the times and places that water is most in demand, such as during the warmer months along the central and southern coast and in the Central Valley, are not those in which water is naturally the most abundant. So the blue circles on the map on the right show total estimated water use in each California county in 2015, with bigger circles indicating more water use. And you can probably tell that this map is almost the inverse of the precipitation map on the left. So to address these mismatched patterns of supply and demand, very extensive networks of storage and conveyance infrastructure have been developed and are operated by federal, state, and local entities, and they redistribute water in time and space. But these systems have important limits and vulnerabilities. For example, they depend on assumptions that snowpack and groundwater storage will be able to continue to serve as large additional water supply reservoirs. And all of these connections, both natural and built, create interdependencies that give decisions that are made in one time and place potentially far-reaching impacts. As a result, how water is managed during water times affects what water management options are available during droughts and how droughts impact people and ecosystems. So decision-making for different aspects of California water management occurs at the local, state, and federal levels and involves a whole array of different government and private entities. And I should mention today that when I'm talking about water allocation, there are lots of ways we could look at this, but I'm going to be kind of focusing on from a water rights perspective. So folks who are diverting water from streams and rivers and other waterways on the surface, or who are pumping groundwater and have some kind of a right to do that. There are also a number of other ways that people access water, usually from one of those entities that has a water right. And so including some of that actually, just to go back here to this slide, sorry. Some of the entities that operate these big networks of storage and conveyance infrastructure. So there are contracts under those, and a lot of water is sort of used under those. And I'm not necessarily going to be talking about that today, although it's definitely a big, important part of California water. Okay, so now all right. So many water decision makers, because different government agencies have been assigned to focus on different aspects of water and water decision making, that decision-making is often really siloed, highly fragmented, and localized. For example, there's many thousands of water systems of many different types currently providing drinking water across the state. So information of various types provides really critical context for water decision-making. However, water managers and regulators in California often face serious data constraints that hinder timely, effective, and equitable decisions during droughts and other times of water shortage. These include incomplete, inaccurate, inaccessible, and untimely information about water supply, water diversion and use, water rights, and impacts to people and ecosystems. Although the state has made some important headway on data improvements in recent years, there's still a long way to go and a lot of room for better information sharing between state agencies and local water managers. I mentioned stream gauging, so just as an example, sort of zooming in on the San Joaquin Valley here, all of the stream segments shown in sort of the reddish color, sort of purpley red here, are considered to, or were at the time of this report, considered to have been poorly gauged. So we did not have great information about the water supply in those portions of the watershed. So just as an example of a data issue. Drought is really common in California, and just times of water scarcity in general. This figure shows the spatial distribution of the Palmer Drought Severity Index during June of each year between 1970 and actually 2022. So not quite up to date. Past major statewide droughts are identified here with these tan bands that have sort of year spans on them. But you can see that there's a lot of yellows, oranges, and reds across various parts of the state during many other years. And it's just a fact that seasonal water shortage occurs essentially every year in many areas of California. So climate change is raising the stakes for effective drought response and effective management of water scarcity. Warmer temperatures are increasing hydrologic extremes, affecting the timing and volume of runoff and exacerbating inadequacies in California's water infrastructure, management, and legal and policy frameworks for both dealing with extra abundant water and for times of water scarcity. Here we can see that the last 4 major statewide droughts from the 1976-77 drought to, and actually, it's actually the last 5, up until our drought here, 2020 to 2022, were each kind of successively warmer than the last, or at least staying in that warm zone. With the same amount of precipitation, a warmer drought will be more severe than a cooler one, since increased evaporative demand will lead to less runoff making its way to rivers, reservoirs, and groundwater, as well as to increased demand needed to meet the same uses, like growing a particular crop. And California droughts are becoming more frequent and intense. This chart shows the percentage of California's land area that fell into different categories of drought, according to the US Drought Monitor, from 2000 on the left up to basically today on the right. Essentially, major droughts have shifted from being very infrequent exceptional events, sort of toward the earlier part of the 1900s, to becoming more frequent episodic events, and they're now just really becoming more and more common. So much so that, yeah, I mean, it's hard to talk about them as droughts because they're kind of, there's mega droughts, and there's ways to describe this that are much more kind of an ongoing thing. So this is sobering, but it's really important to recognize. It's becoming increasingly clear that it's really not feasible to treat drought in California as an unpredictable emergency rather than as a basic water management challenge. So that's why I'm going to frame it more as water scarcity mostly when I talk today, as opposed to drought, because it's something that we face a lot. So now I'm going to jump to kind of a hopefully brief overview of water rights in California, just to give you an idea of some of the complexity there and the different systems that we're working with. I also want to mention that really the legal and regulatory context for California water management decisions is very complex. First, we have water right priority rules that help determine who gets water when there's not enough to meet all demands. We also have laws that affect groundwater, including a 2014 law that requires local water managers to manage groundwater sustainably, which I'll be talking a little bit more about later. Additionally, there are a host of state and federal protections for environmental water uses, including California's unique public trust doctrine, which requires the state to protect public trust uses, including use by fish and wildlife, whenever feasible. So similarly, there are state and federal laws that include protections for human health and safety uses of water, such as California's human right to water, which was adopted in 2012. You'll see that I've drawn kind of a dashed box around the outside of all of these, and that's there to symbolize California's reasonable use doctrine. I'll just mention quickly that this is a potentially very powerful but underutilized requirement that's codified in Article 10, Section 2 of California's Constitution. So in California, a water right gives the holder the right to use water as opposed to ownership of the water itself. And Article 10, Section 2 expressly limits every water right to the amount of water that is reasonably required for the beneficial use to be served. And it makes clear that a water right does not include the waste or unreasonable use or unreasonable method of use or unreasonable method of diversion of water. The California Supreme Court has held that what is considered reasonable necessarily changes with time and with the facts and circumstances of each case. But reasonableness is not a purely local matter. Instead, the Supreme Court makes clear that whether a water use is reasonable also involves what the court calls statewide considerations of transcendent importance. So, for example, some uses of water that might be reasonable during a wet or average year might not be reasonable during a time of water scarcity. So rights to divert and use water are not administered through a single unified water right system in California. Instead, they're divided into multiple overlapping and incompletely integrated systems and types of water rights that don't necessarily reflect hydrologic realities, like the fact that groundwater and surface water are often interconnected. This slide summarizes the major types of water rights and some of their key characteristics, and I'll talk a little bit more about them. So when California, so first looking at surface water rights, when California became a state in 1850, it initially followed the practice of eastern states and adopted a system of riparian water rights, which are rights to use water that are based on ownership of land adjacent to a water body. Riparian rights are correlative, which means that during a water shortage, everyone with a riparian water right is supposed to share in that shortage, reducing their water use proportionally. However, as miners flocked to California during the gold rush, they started claiming rights to take water from water bodies without owning adjacent land and transporting that water to other locations to enable practices like hydraulic mining, pictured here. So California decided to recognize appropriative water rights too. These rights are based on taking and using water and are assigned priority that's based on the date that the water right was acquired. You'll often hear this called first in time, first in right. During a water shortage, a more senior water right holder is theoretically entitled to take the full amount of their right before any more junior water right holder gets any water. On top of this hybrid system of water rights, primarily governed by court-made law, California created a statutory system for administering new water rights in 1913. As a result, all appropriative surface water rights established since late 1914 now require a water right permit, license, or registration from the entity that is known today as the State Water Resources Control Board. So now taking a little look at groundwater rights, like riparian and pre-1914 appropriative surface water rights, groundwater rights are also largely based on common law. In this figure, you can see that they have a largely parallel structure to the surface water rights with kind of flavors that are correlative, which are called overlying rights, and appropriative. And an overlying landowner basically has the right to extract a reasonable amount of groundwater in light of the demands of other overlying users to support beneficial use on their land within the basin. If there's water that's surplus to the needs of all of the overlying users in a groundwater basin, then groundwater can also be pumped for appropriative use. Water under appropriative groundwater rights is theoretically only available when a groundwater basin is not in overdraft, is not overdrafted. However, in many groundwater basins in California, far more groundwater has been pumped than is being replenished. In these basins, appropriative pumpers, including cities, which are defined as appropriative groundwater users under state law, can acquire what's called a prescriptive groundwater right, which I am highlighting here, but just by continuing to pump despite the overdraft. So they're kind of using water theoretically in violation of how they should be under an appropriative right, but they can acquire a right over time that way. I also want to mention that I think it's important to recognize that California was developing its water rights law, which tied the right to use water to either land ownership or diverting water for off-stream uses, in concert with using laws and state-sponsored violence to force indigenous peoples from their ancestral lands and waterways to make way for white settlers and enable mining and agriculture. California also adopted racist laws and policies that effectively barred Asian immigrants, Black Californians, and other communities of color from acquiring water rights. The effects of this exclusion continue today and are being magnified by climate change. And I just want to call out that the Stanford Environmental Law Clinic has a web page that summarizes some of these issues and links to an amicus brief that the clinic submitted on behalf of a coalition of tribal and other clients that really lays out the issues in a powerful way and in some detail. So I encourage you to check that out. So now I'm going to talk a little bit about how California has allocated groundwater. Basically, in theory, as I've mentioned, we have the system of groundwater rights that the courts have made that should determine how groundwater is used when there is conditions of groundwater overdraft in the basin, for example, and who gets access to water. However, that's not necessarily what occurs in practice. So, and I wanted to call your attention to here, I made these little pictures of cups of water just to sort of show the distinction between when there's a water shortage, what the water allocation would look like among overlying users. So you can see these cups, when there's a water shortage, they're all kind of half full, which is meant to represent that they're all sharing in that shortage. Then for appropriative rights, it's more of a basically first in time, first in right. And prescriptive rights kind of disrupt that whole process by kind of ending up functioning eventually if you perfect them as an overlying right. So how has California actually allocated groundwater in practice? Well, there has been a lot of unregulated pumping over history, over time. And when there have been conflicts that have developed in certain areas, often in Southern California and some other parts of the state early on, basically there were different ways to address that. And actually there's one I left off of here. But sometimes different water users would sue each other about basically saying you're pumping in this way and it's taking water that I have a right to access and I can't get the water that I need. And sometimes these are basically expanded to bring all of the water users in that groundwater basin, or at least a significant portion of it, into court to come up with a solution and basically adjudicate their water rights. So they decide, the court, with the court's help, they decide sort of, here's the lay of the land with respect to everybody's water rights, and here's moving forward how we're going to manage this water and what everybody's allocations will be. And basin adjudications often we'll do that, sort of establish like, here's what everybody's allocations will be. And then also they often involve a physical solution, a so-called physical solution that has usually involved finding a source of water that's somewhere else in the state and importing it to supplement local water supplies. And so getting everybody to sort of pay into that, for example. Sometimes those allocations are tradable. And so there are examples of sort of water markets and trading in some areas where there have been groundwater adjudications. Also, in some parts of the state, they're sort of in lieu of lawsuits or in lieu of adjudications, sometimes also with lawsuits. The legislature has basically established special districts by act of the legislature in areas that are recognized as having severe groundwater issues. And that's how they'd like to develop basically an entity that is tasked with helping to manage groundwater in that area. So we have some of those around the state. And then in 2014, during the midst of a major statewide drought, the legislature passed and the governor signed the Sustainable Groundwater Management Act. So a little bit about that. You may be very familiar with this already, but if you're not, I just wanted to make sure everybody has a little bit of background here so that we're kind of on the same page. Let's see here. Oops, I think I am jumping slides here. All right. So basically, Sustainable Groundwater Management Act, also known as SGMA, became effective on January 1st, 2015. It required the formation of local groundwater sustainability agencies, which you'll often hear called GSAs, in designated basins. It also required these groundwater sustainability agencies to develop and implement groundwater sustainability plans, which you'll hear called GSPs, by either January 2020 for critically overdrafted basins or January 2022. And these plans were supposed to be designed to achieve sustainable management within 20 years. And what's sustainable management? So sustainability is kind of defined in the act in terms of avoiding 6 types of, quote, undesirable results. So these are basically significant and unreasonable lowering of groundwater levels, reduction of groundwater storage, seawater intrusion, degraded water quality, land subsidence, and surface water or surface water depletion. And so just to show you where SGMA is kind of operational here, all of the basins in orange are higher medium priority basins in orange, or kind of this purpley pink are higher medium priority basins that are required to develop GSAs, groundwater sustainability agencies, and plans to address, to achieve sustainability. And the ones that are highlighted in that purple or darkened in that purple color there's 21 basins that are considered to be critically overdrafted, that have really serious problems or have been identified to have really serious problems by the state Department of Water Resources. So a few more basics. The SGMA has kind of a state oversight component where those groundwater sustainability plans get reviewed by the Department of Water Resources that can approve them or send them back to folks if they need more development. And also if the plans themselves or if plan implementation is just not working out, the State Water Resources Control Board can step in and intervene and temporarily impose some kind of groundwater management, basically a simplified plan that is likely going to involve reducing groundwater pumpings as a major tool while the local area gets their act together and comes up with an improved plan that meets the state standards. However, really the core of SIGMA is that it emphasizes local groundwater management decision-making. So it really provides a lot of tools and flexibility that local groundwater managers can use or not to figure out what to do. And so among the things they can do, but they don't have to, are they can establish groundwater extraction allocations within their territory, and they can allow trading of those allocations under certain circumstances. However, there are some things we think are important to consider, me and my colleagues, if groundwater sustainability agencies are considering this as a management tool. And so we wrote a report about it in June of 2017 that I just wanted to call your attention to. I'm not really going to talk about it much, but that report is called Trading Sustainably, Critical Considerations for Local Groundwater Markets under the Sustainable Groundwater Management Act. And we really think there are a lot of things that need to be considered to make sure that trading does not cause negative impacts to people or ecosystems. And part of that is because in the groundwater context, if you're thinking about trading of groundwater extraction allocations, usually groundwater trading does not involve pumping groundwater up from the ground, putting it in a pipe and taking it to another location. What it would generally involve in this context is, whereas somebody would usually pump from a well in this location, they decide not to pump and they sell their or trade their allocation, their groundwater extraction allocation to someone else who's going to pump in a different location. And pumping and using water in different locations can have different impacts. So we just sort of point out some of the things related to that in this report. Various researchers have examined the groundwater sustainability, boy, it's a tongue twister, groundwater sustainability plans that have come out of SIGMA. Especially, I think a lot of attention has been paid to those that are in the San Joaquin Valley, where there are a lot of those critically overdrafted basins. So folks have been looking to see whether and how they take into account, for example, different stakeholders' interests, take into account and protect different stakeholders' interests. So for example, there's some analysis that looks at how groundwater sustainability plans address small and underrepresented farmers, impacts to domestic wells that are used for drinking water, also ecosystems, things like that. So, and there's also analysis by folks, including, this is a slide from PPIC, the Public Policy Institute of California. They looked at some plans and noted that a lot of the plans or the management ideas that the plans put forward for addressing potentially overdraft and also just achieving sustainability really include, again, I mentioned earlier that the physical solutions of importing more water from elsewhere or otherwise increasing water supply. And a big chunk of that potentially could happen locally with increased groundwater recharge. However, a lot of the different plans, for example, across the San Joaquin Valley, are all kind of looking to kind of the same potential sources or many of the same potential sources for surface water to recharge. And so they can't all necessarily access that. And so that's a potential challenge. Fewer of the plans, at least the plans, are often less reliant on asking pumpers to cut the amount of groundwater they're actually using in different ways. And so that's kind of a little bit of a blind spot and maybe kind of unrealistic in some of these plans. Now, this analysis, I think, was done in 2020. So there may be some changes in some of the more recent plans where folks are addressing these things better. Oh, yeah. So here I was trying to highlight for you supply side solutions versus demand side solutions. So thinking about surface water, shifting to surface water context here, when there's not enough water to satisfy all demands in a watershed, surface water is supposed to be allocated among different human and environmental uses according to the legal requirements and policy priorities that are set out in state and federal law. This is also true for groundwater. But when water is not legally available for a surface water user or a groundwater user, that water user should curtail, in other words, reduce or stop their own water diversions. And this is kind of how California has addressed allocating surface water in a lot of years. There are, some of the entities that have water rights are actually big water agencies themselves, so they do a lot of further management. But in terms of the water rights, in a lot of years, folks have just been left to kind of figure out how to implement this themselves and figure out whether there's water available for them to take or not. So as I think I mentioned previously, just wanted to sort of refresh your memory, where we're talking about riparian rights. What that allocation should look like is that during a dry period, everyone shares in the shortage. And for appropriative rights, during a dry period, I think I said wet period before, but during a dry period, basically the most senior water rights, if you were looking at water right priority alone, should get all the water that they need before more junior users can partake. There are also, I think, all these other legal and policy priorities, legal requirements and policy priorities I mentioned that, including the reasonable use doctrine that wraps around these things that can change how that plays out. But that's kind of the basics. So, so theoretically, these things are supposed to be implemented in when there are times of water scarcity. However, it's also important for the state to provide effective water rights oversight, because at the most basic level, it's just not easy for individual water right holders to figure out when water is or is not available to them. So those with more senior water rights may divert water downstream from more junior water users. And so water released or water released from reservoirs may belong to other users or be required to meet water quality requirements. And in some stream systems, there are minimum flow requirements to protect species and ecosystems. This means that if a water diverted sees water flowing by their point of diversion, it may not actually be legally available for them. So part of what the State Water Resources Control Board and the state in general needs to do is to provide some help implementing curtailments to make sure they happen when they're needed. So one way to explain this is that, kind of much like stoplights and signage are needed to routinely direct traffic, the state needs to routinely take steps to implement water right curtailments, such as letting water users know when water isn't available for them. Because the amount of water that's spoken for in water rights and claims exceeds the available supply in most years, this really means that implementing curtailments ought to be seen as a basic function of the state, something that's really inherent, and it's something that I think should be thought of as inherent in California's water rights system. So I just wanted to talk fairly quickly here through a report that we put out last year. So we, recognizing, or at least in our view, recognizing that this is a need for California to do a better job sort of implementing California's water rights system during times of scarcity, we looked into really the legal context for water right curtailment in California. We analyzed the history of curtailment practices in California going back from the 1970s and those, I mentioned that major statewide drought in the 70s up through 2022. And we kind of had an emphasis on that really kind of the most recent major statewide drought there from 2020 to 2022. We also looked into curtailment practices in other Western states to give us some context for what maybe could be done differently or in how other states are doing things. So we developed this report called Managing Water Scarcity, a framework for fair and effective water right curtailment in California. Oops, sorry, just getting distracted here. Oops, now I have gotten off of my. And so what we found was that the State Water Resources Control Board has rarely implemented curtailments. It has taken some steps to implement curtailments in some California watersheds during some major statewide droughts. And so these are kind of those watersheds, the ones in green, various greens here, where something has happened. And really the Delta watershed, which encompasses both the Sacramento River and San Joaquin River watersheds, is where the Water Board has concentrated most of its efforts to implement water right curtailments to date. This slide shows a timeline of curtailment-related actions that the Water Board took in the Delta watershed between 1970 and 2022. And what I want to highlight is that the Water Board has only issued drought-related curtailment orders during the last 2 major statewide droughts. And these are sort of the times that are identified with black arrows. In 2014, 15, and 16, the Water Board issued curtailment orders to protect fish flows or flows for fish in a few tributaries to the Sacramento River. The only time that the Water Board has issued curtailment orders to diverters across the broader watershed is basically 2021 and 2022. So again, this is the watershed where the Water Board has done the most work to implement curtailments. So we also looked into it. I'm not going to get into the details of this, but basically the Water Board's current approach to implementing curtailments is really its most advanced and effective yet. But this approach we found still has some really important limitations. And I'll just flag for you that the current approach that they've been using in 2020 and 2021 especially, and they used a little bit in the prior drought, is to rely on adopting emergency regulations to lay the groundwork for issuing curtailment orders. But this is an authority that is only currently available to the State Water Board in basically the 3rd year of a drought or after the governor declares a drought emergency. So that is kind of a challenge. So I mentioned that we have a lot of variability and conditions change. And so if they can only adopt these emergency regulations only in sort of the 3rd year of a drought, or after the governor declares a drought emergency, that can be a problem. Additionally, current enforcement options are really inadequate. So damage from unlawful water diversions happens immediately, but the enforcement tools that are currently available take weeks to months to implement. So, and kind of the fastest ones take like at least 20 days. So additionally, the maximum penalties that are available are too small to deter many serious violations. So a good example that you may have heard of is that in the Shasta River, basically there was a group of diverters, they're members of the Shasta River Water Association, that in, I think, August of 2022, diverted, they were supposed to have their water rights entirely curtailed, but instead they diverted more than half of the Shasta River's flow for 8 days. And the maximum penalty available, because these diverters had pre-1914 water rights, was $500 per day times 8 days, which is $4,000. Split that among about 80 water users. So it's about $50 per water user. So that is not a very serious deterrent. So what has this meant for California? In brief, when the Water Board has implemented curtailments, they have been belated, uneven, and contested. This figure provides an illustration. It just shows a timeline of curtailment-related actions and flow for the Shasta River watershed between October 2020 and September 2022. There's a lot going on here, but I want to draw your attention to a few things. So first, the yellow zones here are time periods before the emergency curtailment regulations were in place, when curtailments would have been warranted under the terms of those regulations. So these are times when the Shasta River's flow dropped below the emergency regulations drought minimum flow levels. The reason it took so long for the Water Board to implement curtailments was that 2021 was only the 2nd dry year in a row. So it had to wait until May 2021 when the governor declared a drought emergency for that part of the state. So that's shown by the first black arrow labeled number 1. Before it could begin the process of adopting emergency regulations to lay the groundwork for curtailments. Those emergency regulations then went into effect in late August, which is the 2nd black arrow. And then the 3rd black arrow shows when, so the curtailments were implemented pretty soon after that, but effectively, so I just wanted to mention that it's basically like more than 4 months before the board was able to issue curtailment orders. Curtailments would have been warranted in 2021 and even the prior year as well, or 2022. And boy, I'm getting my years tangled up. But basically, this curtailment violation occurs here at this black, the 3rd black arrow. And the reality is that when the Water Board relies on belated emergency regulations and inadequate enforcement mechanisms, it can't effectively stop people from taking water out of turn. This deprives more senior water users of water they're entitled to, forces communities to struggle to meet basic human needs for water, and harms the ecosystems we all depend on. So I will just really quickly mention a few of the recommendations that we had out of this report for things the state can do to improve how basically water is allocated going forward, surface water is allocated going forward by having more fair and effective curtailments. So we had recommendations that were kind of targeted to the State Water Resources Control Board itself, and then some for the legislature, and then some kind of for the water board that would require support from the legislature. So first, for the water board itself, our number one recommendation was that to not rely only on emergency regulations as the basis for curtailment. So we recommend adopting standard regulations, so permanent regulations that will lay the groundwork for routine curtailments. We also suggest that emergency regulations could be used in a supplemental way, and that the water board develop sort of best practices for using those in that way, so that it's kind of clear to everyone when those would come into play. For the legislature, we think there's a number of different things the legislature can do to help the water board adopt more effective curtailment regulations. And some of this is just clarifying what my colleagues and I really think it can and should be able to do under current law. But basically clarify the water board's authority to implement priority-based curtailments for all diverters. This includes folks with riparian and pre-1914 appropriative water rights and claims, as well as post-1914 folks who have permits and licenses and things like that. Also extending the ability to do emergency rulemaking to all critically dry years, or not just beginning in the third year of drought. And then requiring the water board to adopt provisions of the curtailment framework that need to be updated more frequently. So things that are really watershed specific, that might need changing and adapting, because this is all honestly all kind of new for the state, to adopt those via emergency regulation so that they could be updated more frequently, but allowing them to do it, more under circumstances that are not just third year of a drought. Additionally, the legislature can do things to enhance the water board's curtailment enforcement options, like clarifying that the water board has the authority to address any diverters' curtailment violations, regardless of their type of water right. Again, some of the way things have been interpreted in the past, folks with riparian water rights or pre-1914 water rights are sometimes it's been argued that they are outside of that authority. We don't think that they should be. It doesn't make sense for managing water in California, and it would be helpful for the legislature to clarify that. Also providing stronger penalty options for violations, and expressly authorizing the water board to prevent irreparable harm, for example, by issuing what are called interim relief orders. And I'm not quite sure how it would work in California, but it definitely happens in other states, by physically potentially having the authority to physically shut off unlawful diversions. This is common in other Western states, and California should consider it. So for the water board, things the water board can do with support from the legislature that we think would be really helpful is to improve engagement and information for fair and effective curtailments by strengthening the state agencies' connections with the different watersheds around the state. So we have some suggestions for establishing regional liaisons from the water board, and also potentially allowing more water master positions that are sort of modeled after the Delta water master, which can help with day-to-day implementation of sort of water rights administration in the different watersheds, and provide more information when water scarcity is becoming a big issue. And there's different ways to improve the data that inform curtailments, including by requiring more frequent reporting of water diversion and use. Right now, basically reporting is required generally, so kind of once a year, and it's actually kind of delayed a little bit, and that makes it really hard to make decisions about and understand and analyze what water is actually available legally to folks in real time. Also to do various things to accelerate the development and implementation of in-stream flow requirements. There are various provisions of state and federal law that kind of indicate that these should be happening, but California doesn't have a lot of them. That creates uncertainty for folks and lack of protection for ecosystems. So just to circle back, I'm almost done here, but jump to your questions. But I just want to emphasize that why it's important to improve water right curtailments, because, again, California droughts are getting warmer and becoming more frequent and intense. And curtailments, as I mentioned, are really not only needed in sort of extreme situations, but really somewhere every year in California, there are watersheds that are experiencing water scarcity. So it's kind of a critical thing to get a better handle on. There's some bills that circulated in the legislature last year and some again this year that partially address some of our recommendations, but we think that more comprehensive state action is needed and soon. And I just want to sort of flag that again. I think I kind of mentioned this earlier, but cities don't wait for rush hour to erect traffic lights. The state shouldn't wait until widespread water scarcity strikes again to empower the water board to implement fair and effective curtailments. I sort of jumped around a little bit, but hopefully that was some useful information. Just wanted to mention some of our funding sources for our drought and water scarcity related work. And then maybe I can stop screen sharing and let's see here and take some questions. And I'm afraid I have not been seeing the chat at all. So apologies if I have been missing various things.
That's no problem. Can you hear me? Okay.
Yes. Yes.
I gotcha. So we have a couple of questions, and I'm also going to send you those in the chat as I read them. Okay, so first question. What do you see as the biggest challenge in groundwater regulation currently, and do you see potential solutions? It also goes on, do you see clear implication for agriculture in parts of the state?
That's a really good question. I'm going to have to say I'd have to think about it more to think about what I think the biggest challenge is, but a big challenge, I think, is that, as I kind of mentioned, I think a lot of the plans that different local groundwater management agencies, groundwater sustainability agencies are coming up with are kind of heavy on the supply side improvements and kind of light on the demand reduction elements. And I think there's a lot of acknowledgement that there's going to need to be a considerable amount of fallowing of agricultural land that's currently in use. And I'm not sure that the plans that are out there right now really get as far as they need to with addressing demand, especially I think because some of the management actions that they're envisioning that would increase water supply may not pan out to provide as much water as they hope. So I think figuring out how to address the demand side in a way that kind of provides a little bit of a just transition away from some agricultural water use in some areas of the state. And I think that's a really important thing. And I know there's a lot of efforts, from the state and then also local entities that are working to sort of provide funding for land repurposing and moving land, shifting land to other uses, potentially including solar power production, increasing groundwater recharge, and a lot of other purposes, and creating more habitat for ecosystems and species. So I'm not sure that that's a great answer for the question, but that is an answer for a big challenge, I think.
Yeah, that's great. Second question, wondering how wastewater reclamation plays a role and if it's a viable option for meeting agricultural water needs.
Let's see here. So wastewater reclamation, I think it can definitely play a role. I am less familiar with kind of the cost, kind of how that all costs out, but I think that certainly reusing, treating to an appropriate level and reusing wastewater can be an important source of water for communities and for agricultural users. I think sort of you need to be close enough to the sources of that wastewater to make sort of transporting it to agricultural areas feasible. So there may be, I guess, where there are big agricultural users or just agricultural users who could use the reclaimed water for that would be safe to use for their crops, and they're kind of in close proximity to an entity that is producing, a municipality or other entity that is producing wastewater, treated wastewater. I think it could be a viable option. I think it's probably a less viable option where for larger scale agriculture, at least, where you're farther from sort of a significant wastewater producer, municipal wastewater producer, although I think for smaller scale agriculture, I think smaller communities could potentially figure out water reuse options that will work for small farms in the vicinity. And I'm again not really an expert on those things, but I think that there are definitely some options that could work under certain conditions.
Okay, thank you. All right, next question. What do you think the drought trends mean for the wildlife water programs such as the CVPIA?
That's a good question. So I think that definitely the way sort of conditions have been trending, I think has presented a real management challenge. I know back in 2021, I think especially, there was, 2020 was a pretty dry year, but 2021 was also potentially turning out to be one. I think a lot of the models that we had for how precipitation in certain areas will translate into surface runoff that then makes it into our reservoirs and waterways and is able to be diverted. We're kind of missing some pieces of the puzzle of what was going on because conditions were so much warmer. We had a lot of sort of snow directly subliming and just the soils were really dry, and so they were soaking up more water, and it wasn't making it on the surface to get to the places that we expected it to. And I think there's been a lot of work to try to adjust the modeling to recognize that more. But I think that really posed a huge challenge for some of the basically under the Central Valley Project and the State Water Project. There's certain requirements for flows that they have been meeting, and through certain management operations, certain reservoir operations that they'd been doing that just didn't have the desired results and were really not having good results for the ecosystems they were intended to support. So I think that given that things are trending even worse, I think that's going to be a constant challenge to kind of understand how the precipitation we do get, which sometimes is quite substantial, how that's going to translate into water available for storage or for use in different places at different times, and to work that into effective management of water to make sure that we have water getting to ecosystems and kind of in quantities and at times when it's useful. So I think it's a big issue that I think is going to become a bigger issue, but I know there's folks grappling with it. So that at least is good. I think we recognize that it's an issue now.
Thank you. Last question. What steps would need to be taken to see California prevent unlawful diversions?
Great question. I think some of the steps that I mentioned in the sort of the tail end where I was kind of zooming through some slides, I definitely think that it would be very helpful for California to actually have, for first of all, like penalties that would actually deter someone from blatantly violating requirements to curtail, when water is not legally available for them. And we just don't have that right now, really, especially for due to some court interpretations, especially for pre-1914 water rights. And so I think that some of the things I mentioned about basically improving those kind of the penalty options and other enforcement options, including having a faster way to stop somebody than the current process of cease and desist orders. You basically put out a draft cease and desist order and then have to wait 20 days to see if the party wants to request a hearing. And then if they want a hearing, you have to hold the hearing. And then if they don't want a hearing, on the 20th day, you can put out your final cease and desist order. And when that happens, a whole bunch of new penalties would come into play that if they continue to divert water unlawfully, that those could be effective. But if you're doing anything right now that's under 20 days, that's almost never going to come into play. And like I said, if they request a hearing, it can go on even longer. So having some more immediate ways to step in and stop unlawful diversions when they're happening, and really to actually, I think one of the challenges is I mentioned that kind of the state water board has only been implementing curtailments in certain watersheds. That's a lot due to bandwidth constraints and also where it has more information about water diversion and use, and also the fact that there might be some imbalance that needs some real attention. But I think even in the watersheds that it has been paying a lot of attention, the Delta watershed, it's a very big and complex watershed. I think we were learning fairly recently that, kind of the state's gauging system and oversight and just sort of paying attention to what flows like in different parts of the different watersheds is not as good as it needs to be. So we had, I think, portions of the lower Merced River going completely dry for months at a time, and the state water board didn't seem to know about it right away, and so couldn't really step in since it didn't know about it. So just kind of having a better system for tracking what's going on with water supplies, and I think that was sort of downstream of maybe the major gauge that they were paying attention to for that river. So yeah, I think there are a lot of different things that could happen to help with that. But probably some other things that I did not mention, but it's a good question. Thank you.
Thank you. All right, we've got one other question that came in, and I think this will be our last question. You talked at the beginning of the talk about the divestment of Native tribes on both their land and water rights. Can you talk about how tribal co-management or co-stewardship can play a role in the current fight for equitable water allocation?
Yeah, I think that is really important. And I know this isn't quite directly answering the question, but I know California, in the context of fire management, is starting to, and public lands management is starting to do a better job of collaborating with tribes and on management decisions about how to, for example, use prescribed fire to manage ecosystems, reduce fire severity, and issues that develop with that. And I think in the water context, there are efforts right now, I think at the State Water Resources Control Board, to make sure that tribal beneficial uses of different types, so uses for fisheries and uses for cultural purposes and other things, are getting incorporated into sort of the state's thinking about what water uses it needs to set standards to protect in the water quality context, and that can also include flow. And I think working with tribes on that, and also just more generally on all of these water management issues, and frankly, implementing curtailments and getting the information to do that effectively, and figure out sort of where everybody has blind spots. I mentioned the regional liaison idea of having the state water board have more people out in the field who really are more in touch with what's happening on the ground. And I think that should also happen in conjunction with tribes and making sure they have a good way to interface with the state water board and really let them know when there are challenges going on, and also kind of how what they think should be happening with water management and what they're seeing in the areas that are important to them and in their communities. So maybe not quite the I think there's a lot of room for improving that, even with our current water rights system, right? I mean, there's a lot of people have talked about, kind of maybe throwing out our water rights system, which might be a challenge to do. But I feel like our constitutional requirement for reasonable use and the public trust doctrine are two things that I think can really be used, by the state and by tribes and others to really get at some of these issues that aren't, we can't deal with everything based on, water right priority alone. That's not the only legal sort of requirement we have to look at when we're allocating water. There's all of these other things. And I feel like a lot of the a lot of the historical inequities and the current inequities that are going on can be partially addressed, at least by using these tools to do a better job going forward.
Thank you. I think that's gonna wrap that for today. I wanted to thank you again for taking the time out and sharing all this information with us. Yeah, I think we'll go ahead and close it for now.
Well, thanks so much. I really enjoyed talking to you, even though I cannot see any of you, and hope you have a great rest of your day.
Thank you. Have a good one.
Thanks.
Bye-bye.